Hello, everybody. Welcome on in. Welcome on in. Me and Mia, we say hello, and a quarter of Nancy or half of Nancy over there. She hasn't been in full frame in a while. But welcome in, everyone. And then there's Jan to remind me to put on the right chat. I never will if she doesn't remind me. It's crazy how they move that. Also, if you guys aren't aware, just because I thought of this, and if I don't say it now, I'll forget. If you guys are wondering where the live chat is, when you go back into like chat with some, like to go back and through live, they moved it. And if you don't know where you're looking, like you're not going to know where it's at. So I don't have it up right now because it's already on live chat, but where the search, like where the comment bar is, like where you can, put your comment in. If you click that, if you just scroll over, there'll be 2 dots right here, and then you'll see the live chat option. It's really weird that they moved that. Vincent had to tell me because I'm like, why did everybody turn off their live chat? It was just me. It was a me thing. So I know that there was someone else that was asking about it. So if you guys didn't know, that's where they moved it. They moved it. So, and if this is your first time here with us, well, welcome on in. Welcome, welcome, welcome. My name is Tanya or TitaniumBuilt. You can call me either or. Look at that. 8 months is a long time, Ashley. Look at that. That's an awesome milestone. I love your new picture. I don't know when you changed it, but that's bad that I don't know that. But I love it. I love that. I don't know when you changed that. I didn't notice that. Was that today? If not, I haven't highlighted your name in a while, and I need to highlight it more so I can see your pretty pictures. I love that. 8 months. Man, we're gonna need that. We're gonna need that 1 year, Vincent. That 1 year arm. I wish I would have did a different arm and then saved the rainbow maybe for the year. But I think we had some options that we were thinking about doing, and I forget what they were, but he'll remember. He does the emojis for the channel. He does the emojis. So welcome on in. Hey, Jan. Hey, Susan. And I saw that Alicia was in here. Alicia, I didn't realize you had that many animals. That's crazy. That's awesome, though. I love that. My brother has a chicken. He has chickens. And in the city limits. His dream is to have a farm. He had a farm, and then he had to end up selling out his animals because they lived 40 minutes away, and he worked an hour away. So he would drive 2 hours to feed the animals every other day or whatever. And it was just a lot for him. But his dream is to still own this farm, and he has 9 acres, and he's in the city limits still, but he'll, whatever he can get away with, if he could have a cow, he'd have a cow in his backyard. It'd be the best fed cow too on the block. Hey, Mary Princess, welcome on in, everybody. Welcome on in, guys. Oh, so it's your family's farm. I love that. That's awesome. I bet that was fun growing up there. If you grew up there, I'm sure you did, but I'm sure you grew up on a farm if you own a farm. Usually that's how it goes, I feel like. I don't know. Has anybody in our chat grew up? If you grew up and you lived in the city, did you grow up to be a farmer later in life? I would like to know that, because that would be a lot different. My dad kind of did that. When we moved from Philadelphia to Ohio, my dad didn't have a job at the time because we were moving. And this was in the 80s. And he told a farming guy that he could bale hay. He's like, I could do that. My dad did it. He did it for the whole summer. He said it was the hardest job he ever had. And he was a worker. And he did but he said it was the hardest job. And he didn't know how to do it, but he did it anyway. So, hey, Care, welcome in. So welcome on in, everybody. If you guys don't mind just taking a second, hitting that like button, that'd be great. Subscribe to the channel. We'd love to have you. We are almost at another milestone for the channel. We're, because, I have to look now or I'll say the number wrong. We're almost to 12.9. So almost to 13,000 subscribers on the channel. That's really awesome. We're under 5 before we hit 12.9. I love that. So on our on the channel, when you are a smaller channel, when you first start, before you get 10,000, you go by tens. So every 10 subscribers, you see a number go up. So in your head, you're like, oh, a number went up. Oh, a number went up. It's not very hard to do. But once you hit 10,000, you have to do it every 100 people. You get a bump in your number. So then you're it's just different feeling, I'll have to tell you guys the ins and outs about YouTube one of these days, because I think that a lot of people would want to know that. Maybe I'll do that on my second channel. Give you guys the the scoop. So tonight we're going to go over Delphi. If before we do that, if you'd like to become a member of our beautiful, wonderful channel, I'm going to put the link in the chat. We love to have you. We would. And you just thank you for being here. Appreciate that. So we're going to go back over Delphi. It's been a little while since we've covered Delphi. So we have lots of updates to go over. Over the last live, we were waiting for the court appearance, the court hearing to start in the Richard Allen pretrial. This was the first time that they were allowing cameras into the courtroom. And instead of seeing Richard Allen walking with shackles and chains through the doors, we were told that his attorneys were quitting. And one of them had sent in a written, I think that it was wasn't it written? Jan would know probably. She probably know off the top of her head. I think it was written. He wrote a written statement, and then the other attorney was supposed to put his oral or written statement in within a couple of days. But now those things are changing. Things are switching up just because, it's Delphi. And as long as we're covering Delphi, I feel like it's going to be changing until the case is finally settled. There's going to be a lot of stuff that comes out, I feel like. So they were supposed to start trial in January, and that's what we were all looking forward to. But now with them having to hire in new attorneys, that's probably not going to happen in January. We talked about how at this hearing, they were going to address some of the issues that were going around. And some of those issues were the memorandum that came out. That was 136 pages detailing how Oatnest did the crime, what the crime scene looked like. They detailed that in that memorandum. I read things I've never read in anything before. And we've read PCAs on this channel. I've read horror books growing up, even no, nothing like that. That was graphic. Richard Allen's attorneys were saying that even the guards were, threatening to hurt him or something if he didn't tell his wife and admit guilt, to killing Abby and Libby. So that's why he did, in fact, supposedly, allegedly, that's why he confessed to his wife all those months ago. So then there were the crime scene photos that were leaked to true crime channels. So we had all those come out. And so they needed to address all that. We thought that's what they were going to address in that hearing, but we didn't get the hearing. So we have some new documents to go over, and I want to see what you guys think of these. But before we go over the documents, I was going to go back, just play a short video. It's a 3-minute video to kind of show you the court hearing, because we didn't see the hearing. Nothing really happened, but we didn't see much anyway. I think we streamed for an hour that day. So this will kind of show you guys, if I can get up here, what kind of happened that day. Now, I've never seen Judge Gall before. I didn't know she was a woman or a man. Actually, tell you the truth, I really didn't. But she come walking in there she was a commanding presence. I was like, oh dang, she's coming in there hot, coming in hot. But this is only a 3-minute video. So we'll play this, and then we'll go over the latest documents that have come out. And then I have a couple of little videos to show you guys to wrap it up as well. And I do want to say there are some stuff going on around the world today, prayers for all the shooting victims in Tampa. And then right before I came on the live, there was a mass shooting in Laurel, Delaware. And there's multiple suspects at large. So if you're from any one of those areas, just be careful. If you're from anywhere, just stay in and lock your doors. Don't even go out anymore. When I tell y'all, I'll tell y'all, I tell people in my comment section, sometimes they need to touch grass. I'm going to tell them not to even do that. Just go get some artificial grass and pretend like you're outside, because it's crazy out there. So let me go ahead and play this. If you guys don't mind just hitting that like button, it does help the channel grow. And thank you guys for being here tonight. Sorry, that was kind of loud. Here, let me turn that up a little bit slower for you.
County Circuit Court's now in session. Elmo Frank Golf presiding.
Thank you. You may be seated. We on? All right, we are on the record in State of Indiana versus Richard Allen, 08C012210MR1. Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction. Mr. McClellan, I know that we have already scheduled a hearing in the Carroll Circuit Court October 31st at 9 a.m. I'd like to maintain that hearing if we can, please. I think at that point we can have counsel appointed. I'd like to set a new trial date. Obviously, I don't believe counsel will be prepared within the next couple of months to try a case of this magnitude in January. So we'll set dates for the trial. I think we need to set a date as well for the suppression hearing that was filed now by former counsel. I have asked the attorneys to provide all of the discovery previously provided back to the state of Indiana. I know I entered a protective order on the discovery, and honestly, I don't remember when that was. I think it was in April of this year, perhaps, maybe sooner. But the attorneys have been ordered to provide all of that discovery back to the state. And if you would maintain that until such time as it can be turned over to successor counsel, I would appreciate that, Mr. McClellan. I've also asked the defense attorneys to cooperate with successor counsel. They're not required to do that, but I think that they will in the best interests of Mr. Allen. They're not required to provide any of their work product, but they will be required and have indicated that they will cooperate with successor counsel. So obviously, without counsel, Mr. Allen's hearing cannot proceed. I apologize that I know many of you have been waiting for several hours. I know, Mr. McClellan, you and your staff, and you had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. So is there anything, Mr. McClellan, that you'd like to state for the record?
No, Your Honor, I think we can address the other issues at the October 31st court date.
All right. With that being said, then, we are in recess. Thank you. I'll see you in October.
I agree. There's something, she kind of came in there, like I was trying to see her body, her mannerisms that time, because I've listened to this and I've seen it a few different times, but I wanted to see, she kind of was like, she wanted to put on the act, like, this is kind of like a, I hate to have to do this today. But at the same time, it was like, almost like she was okay with it. I don't know. If I was a judge and I had two lawyers before me, I don't know. She wanted them to recuse themselves. She wanted them to like either quit. They're saying either quit or be fired. And that's what I said that day that this happened. I said, oh my, good Lord. That's what I said. The judge told them either you resign or we're going to fire you. Like one of those type of deals. Like if you resign and you leave, it won't be as bad on you. Like it won't look as bad. But yeah, she's lacking something like empathy or something there. Like it was like she wanted to have like something, but it was like, did she giggle? No, I did it. But see, I could see that she was like smirking or doing something. Like she was like off. Yeah, very much so. Oh, wow. Oh, man. Isn't this the second judge that they had in this case? I meant to look that up. Before the live. Because, we be covering a lot of cases, but I thought that this was the second. Because I thought that the defense attorneys had a problem with the first judge. But am I just thinking that? Let me know, Jan, because I know you've been following this case very, very much so. Yes, PKC. I think the resolutions were more her idea than theirs. Sounds like one is fighting back on it. Yeah. Yeah, he is. I kind of like that. Like, I mean, the fact that if this person that stands in their conviction, like, like that they're in the right, then yeah. Don't let anybody, just because they have a higher, ranking than you, technically, I guess, it would, don't let them, just got to push them aside. It's just like having, I guess, another coworker that you can't get along with. I mean, if you think about it, they're coworkers in a way, like they got to kind of put up with each other, but they either got to put up or be separated. Maybe they need to be separated. Okay. The first judge was related to the family of one of the girls. Thanks, Jan. I thought that it was like it wasn't nothing big. It just had to be done because he was, I thought it was something like that. She's no judge. Oh man, there's a couple judges I wish we could just take around to each court with us. Okay. So I'm going to start reading. I'm going to put my glasses on here and there. And welcome in, everybody. Welcome in. Oh, got to get those on. And I'll put me, maybe I'll put me in this corner. Make me a little smaller there so you can see the letters. And if it's ever like too big for you guys, let me know. Because I'm blind in one eye. So this thing could be like super big and you guys could be like, I can't even read it. So if it's ever too big or too small, just let me know and I'll always blow it up or just make it smaller for you. Now, I try to go through all the documents and highlight them. So if they're highlighted in yellow, that's going to be just like a court document that was filed through the court for the court. If it's for the state, like if the state puts the document in, it's going to be in pink. If it's the defense, it's going to be in blue. And that's going to be for every case that we cover. So this is the state of Indiana versus Richard Allen. Memorandum regarding possible disqualification or sanctions. Any issues or concerns regarding representation should be focused on the Sixth Amendment and Article 1, Section 13 rights of the accused. Continuity of counsel is critical for adequate representation. Article 1, Section 12 of the Indiana Constitution must also be given consideration. Mr. Allen has developed a strong and trusting bond with Mr. Baldwin. And I'm trying to read my notes. Okay. Mr. Baldwin, he's the one that was, he didn't put his resignation in. He was supposed to do it later on. Or no, I'm sorry. Was it? Or no, he was going to, Mr. Baldwin, he did put in an oral. He did put in an oral argument. Sorry. Put it in oral. I had that wrote down wrong. Sorry, guys. Disqualification of either of his court-appointed attorneys would greatly prejudice his right to counsel in a timely trial. It says, see Barman versus State. It just gives an example involving an accused right to counsel of choice. Barman involved private counsel. The Sixth Amendment guarantees that all criminal prosecutions, the accused shall have the assistance of counsel for his defense. The right to counsel of choice has been described as an essential component of the Sixth Amendment right to counsel. And he's going to, he does have he has the right to counsel, of course, but I think he's going to get it. She was going to call, I'm just going to be technical, just technical here, she's going to call them in, I guess. How does that work in such a high case? How does that make the defendant look like? You know what I mean? If he's stuck there with no attorneys, I wouldn't want to be in that position if I was innocent or guilty. You know what I mean? Really, sucks to suck because, if he did this, then I don't care that he doesn't have attorney. But if he didn't do this, then I do care. And I also meant to say this after the video. I wonder what he looks like now. Because we have to remember, the prosecution told us that he's been eating, sleeping, going to rec. He's been doing all of the things that a good jailer does ever since that he made that call and he confessed to the unalivings to his wife on the phone back in April, I think it was. So, yeah, April. So he probably looks a lot different. That's 10 or 6 months, 7 months. I wonder what he looks like now. That would have been nice to see. It says the authority to remove appointed counsel is limited and has resulted in reversals in other jurisdictions. And then there's given different, those are different examples. I couldn't think of the word. A trial court may not remove a defendant's counsel merely over a disagreement regarding the conduct of defense counsel. Accordingly, the trial court Accordingly, the trial court improperly removed court-appointed counsel with no authority to do so. Welcome in, everyone. A court may remove a defendant's attorney on the basis of gross incompetence, physical incapacity, or continuous conduct. We'll get there, won't we? In the present case, Judge Pinzon did not remove Hess for gross incompetence, physical incapacity, or conduct. Rather, it appears from the order of July 9th, 1993, that Hess was removed for conduct allegedly committed in other cases or outside the courtroom. And they're just giving an example through there. So I'm not going to read through that. But I will read through this. And we actually read this document on our last live, but I didn't read all of it. I just read like sections of it that I had highlighted. So that's why we're going over the whole document tonight. Disqualification of counsel is an extreme remedy for any alleged or perceived violation of court's order. Most, if not all, cases concerning disqualification of counsel involve conflicts of interest. There is no case allowing disqualification when an individual not part of the attorney's office or staff surreptitiously purloins information from the attorney and disseminates it without permission or the attorney's knowledge. Well, I mean, just because there's no case doesn't mean that there's not first time for everything. I mean, really. Furthermore, any sanction first requires proof of knowing, willful, or intentional conduct, as do the rules of professional conduct. Here, the attorney's trust and office were violated without his knowledge. Rule 1.6 IRPC requires disclosure by any attorney, not someone that purloined information without the attorney's knowledge. Commentary 16 to the rules state, a lawyer must act competently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. And the disseminations do not fit that definition. Disseminators. Well, we'll get to that, but the person took it out of their office. I mean, they were under the lawyer's supervision. They should have been, but they weren't. Attorney Baldwin did nothing wrong. He was snookered and abused, which reserved the conviction because the trial court erroneously disqualified counsel when the accused had waived any perceived conflict. We note at the outset that defense counsel was disqualified in response to the state's motion and not in response to a defense request for substitute counsel. Where it is the government which moves to disqualify defense counsel, the burden is on the government to show that any infringement on the defendant's choice of counsel is justified. It's given like little examples again. Okay, that's just part of the example. So these are all examples. I'm just going to go through these. I'm not going to go through these examples because that's going to, I think, confuse the heck out of us. So I'm just going to go to this because they're just citing other court cases. So what they're doing is they're saying like, in this case, this happened. And I want you guys to be like, is that what happened that happened in this case? Because, that just kind of, I feel like that dilutes like our brain. I don't know. It makes me like think of the other cases, not this one. So it says the issue before the court is a horrible tragedy created by persons not related to the defense of Mr. Allen. There were 3 disseminators, one of which committed S after the law enforcement investigation began. It should be considered that nothing has been disclosed that won't be disclosed at trial or hearings. Now, I have a problem with that because like nothing's supposed to be out though before trial. I do have a problem with that, but it should also be considered that there have been volumes of information disseminated by law enforcement and or others not at all linked to the defense team. Mr. Baldwin trusted a friend to respect his office space. He was betrayed. Since that transgression, Mr. Baldwin has kept all Delphi-related items locked in a room or a locked fireproof file cabinet. Furthermore, defense counsel has put together a plan for curative action in which no items will be left unattended for even a second in any unlocked room. When any documents or item from the case is needed for preparing the case, the person using the documents or items will either 1, lock the door behind them when they leave, even for a lunch break or bathroom break, or 2, return those documents or items to the room dedicated to the Delphi case and lock the door. Where do they have these, just like laying on an office table somewhere? I just wondering. Because you think that they would have already been locked up somewhere. Like this is a pretty big case and they're not supposed to be, disseminating information. I don't know. Mr. Rossi indicated there are vast amounts of trial preparation materials and it would be a setback to the defense have to relocate them. Under these circumstances, Mr. Baldwin has taken sufficient curative action. Should the court believe there should be some sanction to the court, could order to do 24 hours of representation without compensation. So they say hey, we'll come in on our own dime. Okay. I'm going to grab my drink really quick. So they would have to go up to like the Supreme Court, right? If they wanted to like go above her, like that's what I would assume. Okay. And let's see where we're at. We'll go to the next document. Let me blow this one up a little bit for you guys. Oh, that's too much for you. Okay. And this is going to be the defense. And this is the motion to disqualify. This the first document came out the 19th. This one is the 25th. And this one is motion to disqualify. Comes now the accused by counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules. Did you hear I said rules? I don't know. I can't even do that again. 12B and D of the Indiana Rules of Criminal Procedure respectfully and moves for recusal of and change of judge from Judge Francis C. Gull. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. The comments to Rule 2.11 provide additional guidance. 1, under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. 5, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. Number 3, Judge Gall has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court administrative rules. These proceedings include Frank's motion. Now, before I go any further, the clerk of court, when I'm reading this, I'm wondering if they're talking about like the actual website or if this is a website that only that they can enter in. Because I know that if you go on to like Carroll County, like to go to their records, you only see like the PCA on there. You don't see any of the Franks, like none of that stuff, none of the memorandum that was filed, that 136-page document. I had to get that like throughout, like I had to like search for that. It wasn't on their actual website. So, or maybe Jan sent me that. Did you send me that, Jan? You either sent it to me or I searched for it. Can't remember because she's always helped me with documents for Delphi. So those were never on there. If that's what they're referring to anyway, because it says Judge Gall has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court administrative rules. Those proceedings include Frank's motion filed 9/18/23, Frank's memorandum filed 9/18/23, 3 affidavits, and those were on the Warden Gallipoo, Sergeant Jones, and Sergeant Robinson filed 10/10/23, and the affidavit of the leaker Mitch Westerman. Judge Gall has not removed or hidden any state filings. So that has to be the main website. I never go on there because they never have them on there. I don't know if this is it or not. I'll have to find that. Because I like put it in a certain way. Maybe this. No. But I know that there is a website. I have it like in my bookmarks. So I should have that better. Oh, because I know that like on their website, they have just like the PCA on there. You know, like when you go to one of those, like it's like carrollcounty.com or something. Like Carroll County, maybe it's the clerk of courts. I know it's one of them because that's one was like, Jan's always sending me the documents. I'm like, thanks, Jan. I'm like, I want to read these now because they don't have a website like Idaho does. Now, everybody should have a website like Idaho. I'm going to give it to them. Moscow PD, they did a fabulous job with their website. And then Idaho, the state, has done a great job as well because everything's right there. So, and that's what I guess, you know what I mean? That's what they're saying here. They want their court filings to be on there too. So number 4, Indiana access to court records. Rule 2A provides in pertinent part, all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. And ACR Rule 4 provides that a court record is accessible to the public except as provided in Rule 5. ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. Now, I really want to find that. I think it's this. Let me see if this is it. No, I don't want to be there. I don't want to like do all that. Okay, I'm going to find that. And then I want to show it to you guys because I'm like, man, I want to find that now. Because it literally was just the state side. It really was. Oh, thank you guys for being here. No problem, Chase. Thank you guys all for being here. I appreciate it. If you guys don't mind, since I have you, in one centralized location, hit that like button for me. Also, subscribe to the channel if you appreciate the case coverage. We talk about different cases every night, pretty much. I told Vincent the other day, I'm like, Ashley Banfield, just put me on usually 8:15. Like, something different. We try to cover as many as we can. Let's see. Where were we at? Okay. A court record is accessible to the public except provided in Rule 5. So it says ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secreted from the docket in this case apply to the above referenced documents, which have either disappeared from the CCS or are inaccessible to the public, nor were the documents filed using the procedures required by ACR Rule 5B. It says, i.e. filing on green paper or filing electronically as a confidential document, along with ACR form identifying the specific grounds upon which exclusion is based. By secreting pleadings from the docket without following the access to court record rules, Judge Gall has allowed violations of public access. Because those acts have only shielded documents from the defendant, those actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law, and Rule 2.2, impartiality and fairness. If that's what they're talking about, then I mean, you know, I've seen that website. I remember like thinking there was only like the PCA was on there, maybe something else. It was all like the document. Yeah, it was like all the documents from like right when they came out. It was like maybe like a list, like a. I'm gonna have to find it now because that's gonna irk me. And I have so much stuff bookmarked, you guys. I'm so bad. I need to have like some organization on my computer. Everything else is organized, but not this bad boy. I'll have to get on that. So number 5, on October 12th, 2023, Judge Gall instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely and the effective representation guaranteed him by the state and federal constitutions. Number 6, on October 19th, 2023, Judge Gall conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available. I'm sorry. Hold on a second. I'm sorry. This ain't a laughing matter, but he said this document says she ordered him transported and he was available. Like he was available to come. Like, yeah, he's available. He's sitting in prison right now. Of course he's available. That just made me laugh. Oh man. I didn't catch that the first time I read that. That made me kind of laugh. Wow. Now I took my glasses off and I don't even see where we're at. Okay. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused. This ignored clear precedent. Number 7, on October 19th, 2023, Judge Gall ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and to be removed from the case or to voluntarily withdraw. Either you quit or you're going to get fired, one of those deals. Despite defense counsel requesting clarification as to the topics and or motions to be addressed at the October 19th, 2023 hearing, she gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. Number 8, the same day, Judge Gall had a prepared statement that she threatened to read to the public, alleging defense counsel was grossly negligent in their representation of the defendant Allen. Judge Gall's complaint was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. So pretty much like she was just going after them. It wasn't because, you know, it was personal reasons they're trying to say. Like it wasn't, you know, legitimate. A general summary of Judge Gall's complaints are as follows. A general summary of Judge Gall's complaints are as follows. A press release. So this is going to be like what she did and then their response. And there's a few of them. So number A press release, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response. The intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. Now, forgive me if I'm wrong, but I don't remember them being multiple press conferences. I remember when they announced the arrest, that was a huge day. And then I don't really remember any press conferences after that. Maybe my brain, maybe I'm just like not thinking right, but I don't remember like being a lot of press conferences by the prosecution. B, 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed facts that individuals engaging in Norse paganistic practices may have not only murdered the 2 girls, but that they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response, the court had previously ordered the accused transferred to a state prison at the request of the Carroll County Sheriff. His mental and physical health began an immediate decline. Well, he was put in jail. Prison guards in his area had Odinistic emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defense had video of the patches, and the guards admitted they wore them. That is very true, that they did say they wore those patches. The defense had previously noted a connection between the murders and Odinism. The patches have since been removed. Mr. Rossi cited instances of abuse. Those filings were within the obligation established guidelines imposed for effective representation. Oh, what are you guys singing? I just saw that someone was singing. Man, now, oh gosh, now I've got a song in my head. Man, it's always the same song. It gets stuck in my head. I've sang it on this channel before. Hope I can get it out there so it won't come up. Letter C. Mr. Baldwin had drafted an email to co-counsel but sent it to the wrong person due to self-populating electronic mail. Allen's response. This was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rossi, and the unintended recipient share the same first 3 letters of their first names. The email attachment contained no substantive information, just a bare bones outline of a tiny portion of the discovery received by the defense in this case. He sent it to the wrong person? Well, if you have someone named Bradley, you got to check it more than once because you probably know more than one Bradley. Good golly. So D, the court alleged that Mr. Baldwin had put improper statements in his Frank's memorandum. Not false or misleading statements, just improper in her opinion. Allen's response, the court had disdain for the defense not filing it under seal even though there was no order to do so. The memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. It again was required by applicable guidelines. Not to toot their own horn or anything, you know. E, that Mr. Rossi had filed a tort claim notice to preserve the right of his client. The court opined that his action amounted to gross negligence. Allen's response, the filing of the notice was intended to preserve the rights of a man who was shutted off to one of the most secure detention units in the state. Locked up and isolated with only a tablet. I'm sorry, but that's pretty good. That's pretty good. I mean, a couple years ago, they were still sneaking phones in. You know, I mean, they're still doing that, but you know what I mean. I still can't believe they have a tablet to communicate with the outside world. Allen had no ability to speak with his wife in private as his phone calls were all being recorded. Allen's own attorneys were required to make advance reservations to visit him at the prison. It is entirely impractical that Allen would have had the means to prepare his own tort claim notice and or secure private counsel to do so. You know that they still communicate in prison with those things to each other. If they're passing those things back and forth, they might clear some stuff out of it. But what if they don't clear like a certain app and they like have like a back ways? These people in jail will have a back ways of like talking. They will talk through letters, like numbers, and it will be turned into alphabetical letters. Like, you know what I mean? So like it could be in the calculator even section of it. I wonder how they do that. I bet they do something Has anybody been in jail with a tablet in here? Anybody? Because I want to know. F, Mr. Baldwin had hired a lawyer to represent him in this matter. I also want to know, do you have to buy the tablet, or is the tablet given to you and then you put money on the tablet? How's that work? How's that work? Hey, Yankee Kyle, welcome in. Hey, Gary, welcome in. Welcome in, everybody. It's good to see you guys. Okay, so it says F, Mr. Baldwin had hired a lawyer to represent him in this matter. Alan's response. This was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related S word. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court has sorry, she's snoring. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualifications. The true facts in this criminal case are often volatile. There was no untruth. There was no untruth. G, the dissemination leak of crime scene photographs in which neither Attorney Rossi or Attorney Baldwin had knowledge of nor participated in. Alan's response, see affidavit of Mitch Westerman, previously filed. Number 9, Guideline 1.1 of the Indiana Police Defenders Council Performance Guidelines for Criminal Defense Representation states, the paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defender Association, the National Advisory Commission on Criminal Justice Standards and Goals, and Rule 1.1 IRPC. Everything cited by Judge Gall as concerning was either not attributed to either Rossi or excellence and an ethical lawyering in the best interest of the client's defense and mental and physical well-being. Number 11. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gall showed no concern and did nothing. Okay. I thought I read that backwards for a minute. Number 12. The court has routinely expressed umbrage at the defense counsel representation through investigations and filings while silently abiding the prosecution's discovery delays and false statements by them or their agents. 13. On October 19th, 2023, Judge Gall coerced an oral request to withdraw from Attorney Rossi that did not comply with Rule 3.8. Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in this cause. 14. Judge Gall has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. 15. Throughout these proceedings, Judge Gall has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. 16. Counsel for the defendant are appointed proper counsel, and upon appointment, judicial control and oversight of the appointed counsel is appropriate. So, I mean, the defense wants the judge to be out. Why don't we just kick the defense out, kick the judge out, and just start all over? I mean, we could. We could. And then, I don't know. I mean, maybe he would get a better counsel that way. Do you think they're gonna? I don't know. I don't like this. This case has to be complicated, right? We weren't getting any information until we got that memorandum, and then it was like sensory overload. Number 16, counsel for the defendant are appointed proper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail the representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It has also done so of its own accord without any precipitating motions or requests. No due process has been afforded. Number 17, Rule 2.11 or 11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Number 18. Rule 1.2 of the Indiana Code of Judicial Conduct states, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Number 19. As previously stated, Judge Gall strong-armed attorneys Rozzi and Baldwin with a prepared statement that she intended to read into the record had either attorney resisted her efforts to remove them from the defense. I wonder what that note said, like the letter, the statement or whatever. Within minutes, Judge Gall took the bench, started the record, and informed those present and the viewing public that there existed an unexpected turn of events with the defense team withdrawing from the case. Judge Gall further stated that these circumstances were clearly outside of our control. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunals. How do you say? We're going to look that up. I can't look it up either. That's okay. Lack of integrity and impartiality towards the public and usurp defendant Allen's right to competent legal representation. Normally I can highlight the word Nick and pronounce it for me if I need help. Number 20. Rule 2.2 of the Indiana Code of Judicial Conduct requires that a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Me either, Roseanne. I hope he doesn't pass away in prison either. But I'm thinking that he might look better because, well, we got to think of it like this. When he first went into jail was October. October through April, he was losing weight. He wasn't eating. The judge, even the guard said he wasn't eating. He wasn't sleeping. He wasn't going to rec. He wasn't doing nothing. He was eating paper in his cell. Then he calls his wife in the beginning of April and he's like, hey, babe, I did this. I did this crime. And then as soon as that phone call is over with, he goes back to eating, sleeping, going to rec. Everything's hunky-dory. But the attorneys got that picture of him prior to him making that phone call. So I'm thinking that he might look better with it because it's been 7 months, since we've seen him. This is what I don't know. He could look a lot worse though, but I don't know. I wish we could have seen him. That's why we need to see the defendant. So that way JLR can yell at him too a little bit. I bet he's mad. It says, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. 21, Rule 2.15 of the Indiana Code of Judicial Conduct in pertinent part states, be a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority. It does not indicate that any such opinion of the court allows removal of appointed counsel without due process and against the wishes of the accused. 22. Judge Gall has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. Wow. This is Bradley Rozzi signed off. Okay. They mad. They're a little mad. But I feel like, yeah. Well, if it was just, I don't know. The only thing that gets me with the judge being at fault with this is if it was just the memorandum that came out, you know what I mean? That memorandum was graphic. When I was reading it to you guys, the crime scene, I put a photo up so that you guys didn't even see the writing. And I was trying to skip words and I'm reading it and I'm like, I felt like I was going to physically get sick that night. Like my stomach hurt. I mean, they talk about things that, oh my Lord have mercy. I was trying to like word it differently. And I'm like, if YouTube hates the way I talk, then YouTube hates the way we talk. We can't really, dance around some of the stuff we got to say. Oh, is Chase going to go? Good night. Good night. Raining cats and cows. Cats and cows. I love that. I've never heard cats and cows. I love that. I'm going to start using that if you don't mind. That's better than cats and dogs. Cats and cows. Because it just kind of fits our chat because we've had cows in the middle of the road. We have a cow as our like team mascot. And my dog's back here snoring. We'll do like an intermission. We'll put me up here. Oh, I just covered her face. Here we go. She's sleeping so good. She's sleeping so good tonight. I like just shut the door and she stayed in here with me. I was really excited. Oh, look, I went back on the one I needed to go on too. Let me put me down. Oh, I've got my drink and put me down there. Maud the cow. Yeah, I'm wondering if the tasing is true, Rose. I'm wondering that too. I'm wondering if the tasing was. But yeah, that's what I was gonna say. Like, if it was just the, that's what I was saying. If it was just the one, sorry, I kind of like stopped my thought there. If it was just the, like the memorandum that came out and not the crime scene photos as well, then maybe. But with both of them dropping so fast together, it's like almost like, and that's just some really bad luck, if not. Oh, Rosanna, I don't know. I read that memorandum. They are either the best storytellers on the planet, and they somehow matched up some of this stuff, like at least a little bit to like what they're saying, and it's true. It's, I don't know. It's a lot. It's a lot. I don't know. You think there's going to be a mistrial? This new lawyer really? I have a video that he got a new lawyer, but I didn't really get a look into it yet. T. Salas said the new lawyer assigned to RA is the same lawyer who spoke against him in news interview. He also is friends with the judge. I heard on another channel. I didn't get to watch the video because I didn't get to watch it, and I was so mad at myself because I didn't watch it. But she was going over. She said that he got some new lawyers, and that she went onto their website, and they had like 1 star, like on their Google reviews. Like my boutique, and don't anybody go give me a bad review. I have like a 5.0. I have 5 stars. I'm so happy with my reviews. My reviews are so good. I would just be, oh my Lord. So the judge appoints the attorneys. Yeah. Doodlebug, you're right. That's not looking good. She's friends with them on Facebook. Oh my Lord have mercy. Oh my Lord have mercy. Oh Lordy. Well, I mean, they do live in a small town though at the same time. How does that work? How does that work? Because like you're gonna be friends with somebody. I mean, people like, is that fraternization? Because like that, would that be fraternizing? Oh, Jan said the same thing. Man. The other lawyer's been suspended before, Jan. Oh man. Oh, you guys are so smart. Oh, Allen County. Oh, because she's in Allen County. I forgot. She's not Carroll County. So, but they're having the trial in Carroll. Couldn't they get a lawyer from Carroll County? Judge isn't supposed to have a Facebook? Oh. Well, we see you, Judge. Judge Gall. She's got a lot of gall. That's what I don't know. That's just that name. I don't know. That's what I want to say every time I think of her name. Very funny. Very funny. Like I said, maybe I don't know. What's what's the best thing for Richard Allen right now? Richard Allen's probably freaking out. You know, like I'm trying to think if I was in his position, if I was guilty or innocent. I mean, either way, you had two attorneys that you trusted with, I'm sure, information that nobody else knows, something, and now they're gone. Like, that's supposed to be your trust system, because that's like really all you have. I mean, the wife ain't talking to him, so do you think that it would just be his, you know, he would want his attorneys? I don't know. I wonder how that like that ride back went with him in the back of that paddy wagon or whatever, you know, just sitting there. Like, he was expected to go on camera for the first time, like really on camera. You know, for the first time they were going to put cameras in the courtroom, and then all of a sudden it's like, nope, just kidding. That's not cool, guys. We were ready for that. That's true. Yeah, maybe she picked a bad one to Oh, there's not many to pick from. And then that's just going to be hard. I mean, I don't think they should take him off the case. I think that's just kind of hard. And if you're going to keep one, you got to keep them both. You know what I mean? You can't pick and choose. I think that, but maybe only if the judge and these attorneys can get along. Like, if they can come to some sort of agreement where they're not going to be doing this stuff, they'll be able to get along the rest of the trial. You know, then maybe we just pretend like that we didn't have that hearing on the 19th, and then we just have the one on the 31st. They've got to figure this out tomorrow, though, because they have their next hearing on the 31st. Oh, yeah, Rose, I saw that. Yeah, but I don't think that's because he broke his iPad there for a while. I don't think that's why they weren't talking. But yeah, is her name Kathy, right? Yeah, we got pictures of her, and then I think his mother. It's either her mother or his mother. I think it was his mother outside the court. That's crazy. Stephen said this case smells fishy. The new lawyer was critical of Allen last year in a TV interview. That's what they're saying, Stephen. You know the case really well, too. I'm going to have to look for that interview. I want to see where he was. Can you imagine being Richard Allen right now, guys? Like, I mean, I'm not trying to if he is guilty, he's guilty. And I'm not one of the, you know, but I'm saying but everybody should have counsel. And if he's literally getting the defender that was just making making remarks last year about him. And now that's like, could you imagine he's in his cell and they're like, your lawyer's here to see you, and the cell door's open and he sees that guy. Jan, I was going to ask you that. I wasn't sure if they were going to have cameras or not on the 31st. Well, you know, we're going to have to sneak in there. It's not closed court though, is it? I wonder. So on the next document we're going to go over, let me see these ones right here. These ones are all like just like a page or a couple pages. They're not very long. So here's this one. It says motion for continuance. Pretty much they want a continuance for the 31st. So it says comes now the defendant. If you're just now joining us also, if anything that's in blue is going to be filed by the defense, anything that you see that's in pink will be filed by the state. Anything you see that's in yellow is going to be filed by the court. I really need a banner that says that for you guys, so we can, until we get it in our, until I'm like on the platform for a while and then everyone remembers. And it'll be like that for every case. That way, if you come in and we're reading a document and you're like, who is this, the defendant? Is this the state? Who is this? You'll know. I was trying to make it easier, but I think it probably made it harder. Comes now the defendant, Richard M. Allen, by counsel Bradley A. Rossi, and respectfully request that this court continued the October 31st, 2023 hearing set in this cause. In support of said motion, defendant Allen states as follows. Number one, counsel for defendant Allen is unable to locate any specific order wherein the court scheduled the initial October 31st, 2023 hearing date, nor there any order which articulates exactly what matters were to be addressed and how much time was to be set aside to address said matters. Well, that sounds like they just kind of want to know what's going on before they go in. Number two, however, counsel does acknowledge that there have been discussions between the court and lawyers regarding the October 31st, 2023 hearing date and the possibility of the court conducting a hearing on the pending suppression motions filed by defendant Allen. Number 3, on September 18th, 2023, defendant Allen filed his motion for Frank's hearing. The court has yet to issue a ruling on said motion. Oh, that's a while ago. 4, on October 2nd, 2023, defendant Allen filed his supplemental motion for Frank's hearing. The court has yet to issue a ruling on said supplemental motion. 5, on October 3rd, 2023, defendant Allen filed an additional Frank's notice. The court has yet to issue a ruling on the issue raised in said notice. Number 6, on or about October 14th, 2023, this court ordered defendant Allen's defense team to cease all work on defendant Allen's behalf and therein prohibited counsel from engaging in preparation for the October 31st, 2023 suppression hearing or any other matters associated with this case. Number 7, on October 19th, 2023, the court engaged in actions which resulted in the court ordering the oral withdrawal of Attorney Baldwin from this cause. 8, Attorney Rossi remains the only active attorney of record in this cause. Now, I'm wondering if that's because he technically has to have an attorney until he gets a new attorney. Like, I'm wondering if they have to overlap. Number 9, on or about October 25th, 2023, Attorney Rossi filed a motion to disqualify. Attorney Rossi believes that a full and final deposition on the motion to disqualify should take precedent over the issuance of any rulings on the Frank's motion, the deposition of the pending suppression matters, and any other matters of substance which are currently before the court. I can agree with that. 10, further, defendant Allen believes that any suppression hearing in this cause will require more than 1 day of court's time and will require the appearance of witness, which most certainly cannot be secured between now and October 31st, 2023. And 11, it is for these reasons that defendant Allen requests that the hearings on October 31st, 2023 be continued to a date and time following a full and final deposition of the motion to disqualify filed on October 25th, 2023, and for all other just and proper relief in the premises. I can see that. They're saying, hey, at the end of the day, take me to court. Pretty much. Just have a suppression hearing or like a hearing. And I mean, that's all you can really, that's all you can really do. You could, as a judge, you could do that, just be like, okay, well, we're going to do that. This is what you did. This is what, I don't know. Now, do I think that could happen? I don't know. Yes, Janet, they don't want to be let go. Yeah, they don't want to be let go. That's what they're pretty much saying right here, too. They're like, they're fighting it. Fighting it. I'm going to grab a drink really quick. It's just right here, my little fridge. I don't even have to go anywhere. Ever since I went to the dentist the first time, I promise you guys, like, my throat hurts when I read for a while. My dog's back there whistling through her nose. It's really cute. Now, with having all the information, who said that earlier? Who was asking me what I thought about the case after knowing all the information? After knowing all the information, if what they said in that memorandum is true about the crime scene, it would be extremely difficult, I would think, for one person to do this. As much as in my mind, I'm like focused on one person. In my head, I'm like one person, but like one part of me, but the other part's like, no, like the redressing and stuff. If that stuff's all true and the way that the sticks were located, if they were placed there purposely like that, then that's I just can't get my head around that, because that's not people walking around that area. Like, we went there. People were walking around. We saw people. We saw single men walking around. So it's just very strange. This case, the more information we get, the tougher it gets. So this is from the court order or judgment of the court. Oh, Jan, she's been a member for 7 months. I think you've been here longer than 7 months, though. I don't know, but it seems like it. It seems like you've been here with me like since I've started. I love that. I'm so glad. Me and Jan, we do this. I love that. And I love that you're my mod. I really, really, really love that you're my mod. She's the best mod. She's the, like out of all of my mods, because I've got like 10 or 15, 20 mods right now. Jan, you're the best. Jan's my only mod. She's the best. Actually, I have Vincent somewhere, but you're better. I love you more. He's probably listening right now going, you love her more? What? I hope I made you laugh. So this one is for order or judgment of the court. And it says the court notes the following pleadings, which may be resolved without further argument or hearing. It says defendant's motion for broadcasting order is overbroad. The court will consider a broadcast request by the media after notice to the defense and the state by a hearing basis. Therefore, the motion for broadcasting order is denied. So, kind of like almost like Brian Koberger's trial. I feel like they're doing that almost with Brian. Like it's almost like a case, like a hearing by hearing. Sometimes we're going to see things and hear things, and then other times it'll be closed and we won't be able to, see and hear those things. It'll be gagged. So I think that, I hate that idea actually. Because, you then you have to like search and dig and try to figure out if they're going to broadcast it or if they're not going to broadcast it. It's just nice to know that they're always going to broadcast them. But 2, defendant's motion to quash subpoenas requested by the state for the defendant's medical and mental health records is granted as the state is not entitled to such records. 3, defendant's verified motion for immediate transfer of custody is denied based upon the state's response and attached affidavits. The defense multiple motions for a Franks hearing remain unresolved as the court is still reviewing the thousands of pages of exhibits attached to the motions as well as the multiple hours of digital evidence submitted by counsel. The court will continue to review same. Defendant's motion to suppress and supplemental motions to suppress as well as the state's response will be set for hearing upon resolution of the defense's Franks motion. I wonder what they sent them. Like if we got a 136-page memorandum, they probably got a lot to look through. But we read that. We did that. We did it. Oh, hold on one second. My partner in crime wants to leave. I'll be right back. Hold on. That was so funny. Diana Ross too. Doodlebug, no. Not Diana. Oh, I didn't know about her. Okay, hold on a second. While Matthew Perry is on the subject, did anybody else know that Lester Holt, what's the other guy's name? What is his name now? The Dateline guy, Keith Morrison, is his stepson. Am I the only person that was unaware that Keith Morrison was Matthew Perry's stepdad? Anybody else? Because I didn't know that. No clue until today. I saw him walking up to his house, and I was like, for real? I was like, the voice. Do you think that he's gonna do a story? I saw it on Twitter. I almost passed out. I was like, you've got to be kidding me. And the picture they got of him, I wonder if I could, let me see if I can find it. Let me see. Just really quick, because this isn't, I was like, because I love me some Keith Morrison. Let me do this and then put Keith. Oh, there's pictures of them together. Okay. Hold on. This right here is like, okay, let me share this with you. This is him. I'm going to put the volume down, but this is Keith Morrison walking up. You can tell that's him too. Someone got a really it was a sad picture, but it was a good shot of him. It was so sad, but they got like his face. Oh, it was just so sad. He looked like he was determined, like that look I don't know, look he always kind of has. It's just sad. I feel bad for their whole family. I didn't know this until today. I was like, what? I almost fell off the bed. I was sitting on the bed. But okay, so we'll go back to the files now. And I actually think I know where I'm at. But I couldn't believe that. I love Keith Morrison. Yeah, he should read by book. He should do that. If he had a Bible by book or whatever that Bible on Bible listen, like the listen to the Bible things, you know what I'm talking about? I would totally be rocking out with some Keith Morrison. I could listen to him read anything. Like, I mean, he's so good. He's so good. He should be like, they should have him do that as like an extra job. Because he should be the voice of like some books. And I'm sure that maybe he will cover this as one of his stories. I don't know. That's terrifying. And I heard that there was no drugs in his house other than his prescriptions that he's allowed to have. Nothing that was like, and then it was just, they think it was a cardiac arrest or something and he drowned. That's terrible. So back to Delphi. Prior to the scheduled hearing, the state attorney Rossi and Baldwin advised the court they will be withdrawing the representation of the defendant. Court accepts their representation and orders them withdrawn from the cause. Counsel ordered to comply with the previously entered protective order on discovery and are ordered to turn the discovery over in full to the state of Indiana to be made available to successor counsel. Court requests their cooperation with successor counsel in the best interest of their former client, but is not requiring them to cooperate. Court will maintain the hearing currently scheduled for October 31st, 2023 at 9 a.m. in the Carroll Circuit Court for successor counsel to appear. Clerk of the Carroll Circuit Court ordered to remove Attorney Baldwin and Rossi as attorneys of record in this cause. Man. Can you imagine getting fired like that? Man. I'm dumbfounded still. This one came out, I don't know why I can't see it on here, but the 27th. And it's just an order or judgment of the court. And for some reason, I couldn't open these the other way, so these ones aren't highlighted. But it says court ordered or court notes filings by former Attorney Rossi on October 25th, 2023, and takes no action. Attorney Rossi withdrew from this matter on October 19th, 2023, and is no longer counsel on record. Should make sure those records were filed, huh? Clerk of the court ordered to these filings therefore are ordered stricken from the record. Clerk of the court ordered to remove the pleadings from the electronic case file and the chronological case summary as being filed in error. Okay. We just have a couple more. No 136 pages, This ain't nothing. I was proud of ourselves for doing that. Oh, shoot. You can't see it? Oh, shoot. Look at me. I'm over here reading to myself. Thanks, Doodlebug. Sorry, guys. I should knock on the wall right here because Vincent normally will tell me when I'm doing something messed up. Thanks, Jan. I can see the chat now. I look down and I just happen to see Doodlebugs. I can't see document. It's because I removed it to put myself up when we were talking about Matthew Perry. Because, I didn't want to be rude and, I was trying. That's why your girl shouldn't do two things at once. Yeah, that is true. I didn't show the picture. Oh, it didn't come up. Oh, shoot. Dang, guys. Here, I'll play it again. We'll go back to it real quick. So you guys didn't see the video. Oh my Lord. StreamYard. Why didn't StreamYard tell me? StreamYard, you need to start telling me stuff. Okay, I'm going to put it on that really quick so we can watch it. Because I was really sad and I wanted you guys to see that. But this is here and it's up. Let me double check. Oh, look, there we are. I normally will come right back over to StreamYard, but what I did, I just looked in here. I just looked at the iPad to chat. That wasn't smart. But I'm going to leave the volume off. It's just the guy that's the reporter talking about it. But yeah, that's him. And he's like coming up to the scene. It's eerie because he's normally on the other side of those cameras. And that's probably what he's thinking at some point. You know what I mean? He's probably going, what in the world? Now I'm wondering who the mom is. Isn't that sad? He looked, oh, just, it's heartbreaking. And all those reporters, I'm really glad they gave him his space, though. I mean, you know, they really weren't in his face or anything like that. So I thought that was extremely, you know, if they're going to be there because that he knows news, that's their job, to make sure, you know. Now that would almost look like Keith Morrison's brother or something. Wonder if that was his brother. Oh, that's sad. Okay. It's just sad. Everything's so sad. You know? Yeah, sorry I didn't share it with you guys the first time. I enjoyed watching it again. Sorry about that. Yeah, I think I'm sorry. My elbow is doing. I have like the driest elbow in the world, guys. I lean on it too much. I know. My heart breaks for their family too. Like it just his face. He has that. You know, he has like that stern face when he comes on. He almost has that steel stern face, like he's just trying to get to his destination to where he needed to be. And my heart breaks for them, and I hope that they're okay. I know that the last picture that I believe it was the last picture that Matthew Perry put on his Instagram. It was a picture of him in a hot tub. I don't know if it's the same hot tub, but it was on top of an LA like high rise or something. You know what I mean? Like or like mansion in like, you know, LA. You can tell it's in the hills or something. It was beautiful. But I hope that he didn't feel anything. And I hope he didn't feel anything. Motion to reconsider. This one is comes now counsel for Andrew J. Baldwin and moves the court to reconsider the erroneous order to the clerk of Carroll County and the removal of appointed counsel without the opportunity to be heard in support counsel states. And after we're done with these, I have like a couple short videos, a few of them to like kind of wrap everything up too. So if you missed any of the live, you'll kind of know what we're talking about. It says, and the removal of appointed counsels without the opportunity to be heard in support counsel states. 1, on October 26, 2023, the court issued the following order. Clerk of the Carroll Circuit Court ordered to remove attorneys Baldwin and Rossi as attorneys of record in this cause. 2, the county clerk is an elected position duly elected by the people of the county. She or he is a member of the executive branch of government, not the judicial branch. Ooh. Part 3, part of the clerk's responsibilities is to maintain a complete and accurate record of court filings. Now I'm going to agree with that. 4, no judge has the authority to oversee the clerk or order the clerk to alter the record of court filings. 5, a judge may order sealings of filings only if she compiles with access to court record rules, which Judge Gall has not. 6, on October 19th, 2023, Judge Gall obtained a coerced and involuntary oral motion of Mr. Baldwin. That withdrawal is a nullity and invalid as not in compliance with rules 3.8 and 7.0b of the Indiana Rules of Trial Procedure. Mr. Baldwin has never filed a written motion to withdraw and will not do so. He said it. By operation of trial rules, he remains counsel of record. So yeah, what if they say they ain't gonna quit? What if they say they ain't gonna quit and they're not going to get fired? When does that? I mean, like, what if they're like, I'm not going nowhere? I mean, can they do that? Yes, Donnie. Let the people decide. Yeah, give them their day in court, just like they want. You know. He has glow in the dark hair. He does. He's so handsome, that Keith Morrison. I wonder how old he is. He's probably in his 70s too. He's got to be. Man. This one, hold on one second. Next document here.
Recipe.
Recipe. Okay. It's this recipe one. I had to look this word up because I was like, what the heck is recipe? Or how do you say it? I look it up. It looks like recipe, but it's recipe. Comes now counsel for Andrew J. Baldwin and recipes for the recordings and or transcripts of the 2 in-chambers sessions on October 19th, 2023, or alternatively to give counsel access to the records or recordings pursuant to the access to court records account, more specifically Rule 3 definitions for purpose of this rule. So hopefully she recorded everything they said in chambers, but that's what they want. You know, I wonder if they recorded that, if she recorded it. Rule 3 definitions for purpose of this rule. A, court record means both case records and court administrative records. B, case records means any document, information, data, or other item created, collected, received, or maintained by a court agency, or clerk of court in connection with a particular case. Rule 2, who has access under this rule. A, all persons have access to court rules as provided in this rule, except as provided in subsection B of this rule. Rule 4, general access rule. A court record is accessible to the public except as provided in Rule 5. D, a court may manage access to audio and video recordings of its proceedings to the extent appropriate to avoid substantial interference with the resources or normal operations of the court and to comply with Indiana Judicial Conduct Rule 2.17. This provision does not operate to deny to any person the right to access a court record under rule. Respectfully submitted, David Hennessy. Is this his new? Maybe you guys can tell me then about this document. Is this new counsel Robert Searman? I know Jan will know. Oh, he was born in Massachusetts? I could see that. Oh, yeah, I could see that. Banner line. So his real dad? Because we know his stepdad was Keith Morrison. Was he the original Old Spice guy? Because I like Old Spice. I like the smell of it. Yeah, so this is his new attorney. Okay, because I was wondering about that. I was like, what is this document that Jan sent me? Because like I was just like I was so confused. But I figured we would clear it up here. It was like right before the live, so I didn't want to like text you. You'd be like, what? So this says comes now the defendant. Oh, right here it says his appointed counsel. I should have read the damn document, Tanya. It's only 4 sentences, Tanya. I read them all, but I didn't read this one. Now comes the defendant by and through his appointed counsel, Robert C. Searman, and hereby submits the notice of appearance. Please forward all future discovery notices, correspondence, and inquiry to the address. Now, if this guy was like judgmental on Richard Allen just last year, what did this guy think when he got this case? What was he thinking? Like, holy crap, I've got to be the one to defend him, or I don't know. That's really cool that he was from Massachusetts. I didn't know that. They could go pro bono. Yeah, they could. I got a crush on Keith. I do. If I was a little older. He said that Vanderline, I read something today that now we're talking about Matthew Perry, look at us, but I read something today that he wrote. It was beautiful. Remind me at the end of the live, and I'll share it with you guys. Let me write that down. Because it was something that he said. It was long, and it's from him. And it's like a quote or like a post he posted, and it was beautiful. It was beautiful. Keith 76. Woo, Keith. What's your secret? Is it the true crime, Keith? Is it the true crime that keeps you on your toes? Because I feel like it's keeping me on my toes. I like Keith Morrison. Hopefully their families do it okay. So you should never go before your children, no matter how old. Top 6 bombshells dropped in the Delphi murder case as attorneys gets the boot. That's what we're going to watch now. So it was on Law and Crime, and I watched this earlier. I thought it was pretty interesting. So we're going to go ahead and watch this. It kind of just ties everything up for us. And then the Court TV just came out with like a 5-minute, 6-minute video they just did. And it's just over the attorneys wanting back in with Richard Allen. So we'll play this one. If you guys are just getting with us and just coming in, welcome, welcome, welcome. I'm Tanya or TitaniumBuilt. If you guys don't mind, just taking a second, hitting the like button, share to your social platforms. I don't mind at all. I love that actually. And if you'd like to become a what was I going to say? A member. I don't know what was going to come out of my mouth there. Member. If you'd like to become a member of our channel, I'm going to put that in the chat for you guys as well. We would love to have you be a member. We do members only lives, emojis, all that cool stuff. You get a lot of cool stuff being a member. So I'm going to go ahead and play this, and I really appreciate you guys all being here tonight. Every time I look at this lawyer, too, this attorney, McClellan, I always think he's wearing sunglasses when his head's a certain way. His glasses look like they're sunglasses to me.
He's dismissed, lawyers fighting back, a judge in the center of it all. It has been a week of bombshells in the Delphi murder investigation, and we're bringing you the top 6 biggest updates from this case that has been years in the making. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. The man accused of killing 2 young girls in Indiana more than 5 years ago is dealing with some major legal bombshells today. His attorney wants the judge on the case thrown out. I'm going to give you some background here and a little context. So Richard Allen, he's charged with 2 counts of murder in the deaths of 13-year-old Abby Williams and 14-year-old Libby German back in 2017. Their bodies were found near a bridge in Delphi after the girls went for a walk on a hiking trail. An autopsy report shows that the 2 were stabbed, but an FBI agent said that in a search warrant request that it appeared that the bodies may have been moved and staged. Now, despite the girls apparently having been stabbed to death, one of the central pieces of evidence is an unspent bullet that was found at the crime scene near the girls' bodies, and prosecutors claim that that bullet came from a handgun owned by Richard Allen. That's how they tied him to the crime. Well, these murders, they absolutely rocked the small town of Delphi, Indiana, which only has a population of about a few thousand. There was a desperate search for the killer. It really went nowhere for years until police finally announced that they had a suspect. So Allen was arrested last October, and he has pled not guilty. Well, since then, Allen has been represented by attorney Bradley Rozzi, as well as court-appointed attorney Andrew Baldwin. And they've spent nearly a year building this case. In fact, in September, they requested something called a Franks hearing. That means that they suspected a false statement was included in a search warrant for Allen's home. So the goal is to invalidate the warrants so that potentially any evidence that was recovered from his home couldn't be used at trial. It would be suppressed. The defense claimed that Carroll County Sheriff Tony Liggett acted intentionally or recklessly when he omitted or lied about information in an affidavit that he submitted to a judge to get that warrant last year. There was also a motion from the defense last month looking to keep the prosecution from getting a hold of Allen's medical and mental health records. Prosecutors subpoenaed the records from Allen's time in prison, which has been since November 3rd of 2022. The defense called that unreasonable. They said that they doubted that those records would lead to anything substantive, meaning any actual evidence that's relevant to the case. The attorneys also argued earlier this year that Allen should be moved to a different detention center while he awaits trial. Right now, he's in something called the Westville Correctional Center. The attorney said it's kind of hard getting there to see their client, that his well-being has declined since he's been there. They argue Allen, who's not been convicted of a crime, is being treated less favorably than inmates who are convicted criminals. The judge ended up ruling that that wasn't the case and denied the move to a smaller jail. Okay, so that's what's happened in the last few months, but now we want to get into the major bombshells from last week. When the suspect and the defense counsel were supposed to appear in court, instead, the judge came out and said Baldwin was, quote, voluntarily withdrawing from the case and that she suspected Mr. Rozzi would submit his withdrawal soon. Now, the entire announcement lasted only about a minute. Take a listen.
Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, The defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction.
But here's the thing. According to Attorney Rozzi, this wasn't their choice. No, he claims in a court filing that the judge, Judge Francis Gall, ordered Rozzi and Baldwin to cease work on Allen's case, ordered them to do that on October 12th, that they would then have a follow-up meeting on October 19th, a hearing. But Rozzi says before that hearing, the judge ambushed them. This was during a conference in her chambers, and that she allegedly accused them of gross negligence in their representation of Allen, and that she forced Baldwin to resign from the case, and she expected Rozzi to do the same. So now Rozzi wants the judge to be kicked off this case. You see, the issue here is, and why the attorneys may have been asked or forced to be kicked off the case, is because there was an evidence leak that apparently came from Baldwin's office earlier this month. Allegedly, a former employee of Baldwin's had accessed the evidence that was given over under discovery and then leaked some of it to people on social media. The photos eventually made their way to a podcast called The Murder Sheet, and the co-hosts were able to figure out where the leak likely came from, and they reported it. Well, Allen reportedly told the judge he doesn't want his attorneys removed. He says that he has developed, quote, a strong and trusting bond with Mr. Baldwin, and that if Baldwin was taken off the case, that would greatly prejudice his right to counsel in a timely trial. Allen says that it is not Baldwin's fault for what happened, that he did nothing wrong, that he was snookered and abused. So with all of that going on, Rozzi is now asking Judge Gall to recuse herself from Allen's case, saying her impartiality is in question. She has shown a bias against Allen, and her forcing Rozzi and Baldwin to stop representing Allen violates his constitutional rights. Also, Rozzi accused Judge Gall of removing or concealing some of the defense's legal pleadings from the public case summary, which he argues is in violation of local rules. Now, even though Rozzi had filed these motions calling out the judge still issued an order reiterating that, yes, both of these attorneys have been dismissed from the case and their names should be removed from the docket. A lawyer representing the lawyers, yes, that is a thing, a lawyer representing the lawyers, says that Judge Gall doesn't have the authority to remove Allen's counsel from the case based on this private closed-door chambers meeting. By the way, think about this. Richard Allen is supposed to go to trial in January of 2024, only a few months away, but it's being reported now that judge is expected to delay that trial date when Allen and his defense attorneys, wherever they may be, come back to court on October 31st. So we'll get more information then. In the meantime, Richard Allen remains behind bars. And that's all we have for you here on Sidebar, everybody. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.
Oh, okay. So attorneys went back in. One of them didn't recuse herself. So I'm wondering, he's still technically his attorney. I'm wondering if he's going to be his attorney until like the 31st, and then they switch off. And thank you, Jan. That was so sweet. Thank you. Mia, I got you some treat money. She'll be happy. She needs some more treats. She's getting low. And by low, I mean, they've got like bones like this much, but they'll be good through tomorrow. I feel like I'm at Target every day or every other day to get dog treats or cat food or dog food. They're crazy. Our animals are crazy, but they're mine. They're my best friends. So there was this new video. This came out actually right before the live, so I didn't get to check this one out. So I thought we'd watch it together. And it's from, let me make sure I'm on the right thing. Okay. It's from Court TV. And like I said, they just came out with it right before the live. So I thought we'd watch it together. And it just goes over probably kind of what they said on Law and Crime. But it says Richard Allen's attorneys went back in. So they're probably going to talk about that, I'm assuming. So we're going to watch it. It's only like 5 minutes long, but it should be a good listen. But it's not Vinny tonight. I like Vinny because he's got the eyes.
An attorney for Richard Allen is
Means
fighting to
business.
stay on the case and accusing the judge of ambushing him and a fellow defense attorney. Last week in the Delphi murders trial, Judge Fran Gull announced defense attorneys Andrew Baldwin and Brad Rosie would be withdrawing themselves from the case. Now, Rosie filed a motion to continue his representation of Allen, claiming the court ambushed him and Baldwin, placing them in a compromising position. Along with his filing to retain representation for Allen, Rosie has asked the Indiana Supreme Court to step in and remove Gull from the case, questioning her impartiality. Well, today, Gull appointed 2 new attorneys to represent Richard Allen. They are both from Allen County. Now, Richard Allen is charged with the murders of Abigail Abby Williams and Libby German, and they were teenagers who had disappeared while out walking on February 13, 2017. The girls' bodies were found the next day. All right, still with me, trial attorney Brian Silber. Brian, this one is getting a bit messy. I want to get your thoughts on how this is being handled. There were some issues. There was a hearing held. The judge had some options that day. The defense had let leak a couple of different times some information that certainly should not have been leaked. Early on, she was upset at them because they introduced to the press a scathing letter about the prosecution's case. She didn't like that. There was a gag order put on the case. So she had some options. She chose to, at least according to this defense attorney, take them in chambers and give them what he called a Hobson's choice. They either withdraw from the case or she would basically hang them out to dry in court and kick them off the case. And they, of course, chose option A.
You know, it's a highly unusual situation for a judge to remove a lawyer from a case. It's actually very extreme. I don't know this judge. I've never practiced in front of her, but it's also not uncommon for some judges to, no disrespect to them, maybe get what we call, the real lawyers talking, that black robe fever. They kind of hold their position a little higher than they actually are. Maybe there's a battle of egos going on here and she showed them who's boss. I don't know. I'd like to hear more about the judge's reason for removing them from the case, because certainly a criminal defendant, any litigant has the right to pick their lawyer. That is a fundamental right. At the same time, the judge may be onto something. You know, she has to make sure that this gentleman is getting effective representation. And if she feels that these lawyers are simply incompetent, she absolutely should put her foot down, and she may have done the right thing. I don't know the details. I can't weigh in on whether she did the right thing or the wrong thing. But it sounds to me like there's a little bit of drama going on here. And with these alleged leaks, which, by the way, it's my understanding the lawyers denied leaking anything. That is definitely, you can't be trying your case in the media like that. That's a no-go. You should be trying it in the courtroom. And any judge who has to deal with that and attorneys who practice in that way certainly is well within their rights to take action.
Well, a couple of things. One, they didn't deny that they leaked it. They did deny that they leaked it. What they said was they allowed access to their office. A friend, someone they trusted, went in and they accessed the information. They left the information out. It was taken and that person leaked it, which to me, that's no argument at all. You know, that's an argument my kids make to me when there's things going on in the house or things missing or something. So my question to you is, again, you don't have to know this particular judge, but judges, in my experience, do often, I think, do you a favor if they feel like they want to take you off the case. And then they say to you, look, rather than put you and publicly humiliate you, because this is a case that has worldwide interest, I'm giving you the chance to walk away and we'll just move on without you. So it's interesting that they've taken this tact. What's your experience with judges? Do they tend to give attorneys that choice?
You know, it's very rare to see a lawyer removed. I can tell you it's never happened to me. I've never had a judge take me off a case, so I can't speak to that. But I will say one thing. Those lawyers don't work for the judge. No lawyer works for the judge. The judge works for the state of Florida. The lawyers work for their clients. To be perfectly honest, while of course I respect our judges and I will always conduct myself as a gentleman and as a professional, I frankly don't care because I'm here to fight for my client. They can threaten me all they want. I'm going to do what I think is correct. within the law and the rules of ethics and procedure and professionalism and represent my client. They want to go embarrass me, go ahead and do that. I'm going to do what I think is the right thing to do. She may be correct in removing them, but that type of intimidation would not move me. I'm not going to let myself be intimidated by a judge. But again, I'm not the kind of lawyer that's going to do something unethical or unprofessional.
Yeah, and at the end of the day, so whose rights win out? I agree with you. Richard Allen has the right to choose the attorney that he wants according to the motion filed by his attorney. He has created a bond with him. It might affect his due process rights to get rid of him, but he didn't follow the rules of the court, and she made that very clear. So which went out in a weighing process?
Well, if they didn't follow her rules, then she is correct. You know, this story about them giving access to a third party who leaked it for them, they're responsible for that. You know, I think the judge may have done the right thing in the end, but we'll see. We'll see what happens.
Yeah, there's a lot more to come with this.
There is a lot more to come with this case. They're going to go to, well, I guess they're going to have a court date on the 31st. Halloween. Halloween's coming. You knew a family dog who was 21 years old? Oh my gosh. That's crazy. We were talking in the chat about animals. Yeah, my cat's my life. He's my everything. He's probably out there running the show right now. Probably sleeping dead in the middle of the bed. That's what he does. He's 14. My cat's 14. Or 14. He'll be 15. Oh my Lord. My gosh. But believe you me, sir, ma'am, all of us, he has better hops than I've seen him in years. I mean, the cat can jump like no other. He has no like fright. Like the dog comes up to him, and he just slaps the dog upside the head. Just like, leave me alone. Like, it's just so funny. Not the gray dog. The gray dog, she will bark really mean at Rocky, and he just like looks at her. It comes out of her. She'll never like attack or anything like that. Mia's the sweetest dog. You guys know Mia. But she just does this like really horrible bark sometimes. And I'm like, what are you doing to the cat? Like, why are you doing that to him? And he just looks at her. So I have a little calico. I wish I had a picture of him handy. I'm so bad with pictures with my animals. Vincent always has the best ones. He gets the best pictures with the animals. I have like 0 with them. And he has like all these really cool ones. Like he has one with like Rocky laying on his back and he's like looking over his shoulder. And I'm like, why doesn't Rocky lay on my back? Oh, you have a pit? I have a pit boxer. Donnie, yeah, I have a pit boxer mix. O'Reilly. Now she's my little fighter dog. She's aggressive. She was homeless for like the first 3 years of her life. And so she was put into a humane society and she was so terrified. And they put her in the shy unit, but they didn't. They put her beside this dog that just bounced up and down the whole time. So by the time we got there, she was like skin and bones. And we found her and I was like, we got to take her. As soon as we went to play with her, she put her head on Vincent's lap and we're like, okay, this is the one. Your dog's 15 today. She got the good food today, ALR said. Was it the soft food? Because my cat's been living on that for like months now and it's expensive. She got the good food. Well, happy birthday, little doggy. That's so sweet. We just went from, true crime right over to animals. I love that. Rocky Kodak. Aw. You have 4 cats and 1 dog. That's cute. I love my cat. I do. I think the cats are they take care of themselves for the most part. I mean, he doesn't. I don't know why I'm saying that. He doesn't. Every time I go out that door, he runs to the kitchen. He thinks he gets something. Every single time you go near that kitchen. Yep. ALR said, yep. Yeah. Rocky's been on the soft food diet. We're feeding him Crave. That it's like hard food. And I listened to that, that guy from Cat from Hell. Well, he said, and I don't know if I want to follow this because I've been following it for like 6 months and it's like $4 a day, $3 a day or something. We averaged it out. But we were feeding him Crave, like hard food, and we were just free feeding him, which was one bad, I guess. You're not supposed to just free feed your animal. I've always free fed my cats. I've always just left a food bowl there and like feed them every morning. You just put a little fresh on top. With Rocky, I would just pour the whole food back in. I shake the bag and then I put it all out because he's got to be, he's particular. So it looks fresh, like fresh food, even though it is fresh. But he gets more picky. So we started feeding him moist food. Well, Vincent did. Vincent started this madness. He was good for the first 7 years of his life before Vincent came. No, he's just the sweetest. Vincent's the sweetest. So he got him on the soft food. And now we looked it up because we've been giving him like 3 or 4, like, it's just the little like thing, like the little packet things. And like, I don't know, they're like a little cup. And I just put it in his little food bowl. But he's been eating it so much. We're like, he's eating a lot. So we looked it up and they said to give him like 5 or 6 a day. I was like, we've been giving you like 4, but we give him so many treats throughout the day too. Like, so I think that's what it is. He's been eating more treats. So we need to give more food. I like that guy too, Roseanne, the guy from Cat from Hell. I think he's awesome. Oh, Dapple Dash Hands. I bet you on their sisters, Alicia. I bet you that's so sweet. Good God. I bet that's so sweet. I've always wanted sibling dogs. That's the sweetest. When we adopted Mia, from the Amish, and she was brought into this world way better than I was. Like, I mean, like the house that she lived in, like little log cabin, the doggy log cabin, like it wasn't even that owner's house. It was beautiful. But when we met Mia for the first time, she had her little brother with her. Like they were in the cage together and they looked so cute. And I was like, should we get them both? And we didn't, but I'm glad that we did it now because 2 Weimaraners. Oh, I couldn't do not 2 of them. Not 2. That's so awesome though that you have so many animals. I bet that feels good, like because you have something to take care of, you know? And that's really awesome that, like, you know, you're like you still want to, like, you know, do that. Like you still want to take care of them. You're still like active and you still like love doing that. Like that's like, you know, something that you're passionate about. And that's awesome. I wish that like Vincent's mom had like a little dog or something, but she has a cat. I always feel like she's alone. And but she has a cat and she feeds it every night and it meows at the door. And then she said if she lets the cat in though, like the cat wants to go back out. So it just like cries at the door for her. So I think that's cute. Because I always think of his mom, because when, you know, my mom lost my dad, she was by herself. So. Oh, no, I did see your email, but I meant to look into that case. Yes. Is there anything on it? Like anything? I'll have to look up. Let me write that down. Where'd my paper go? It's right here. Yeah. Cause I have like a little list for tomorrow. Jan's email. I saw that you sent me one and I meant to look into the case. And then I think what it was we started talking. I started thinking about Chelsea Grimm that day because we did that live over her. And I was like, that case is another one that's crazy. So good night, Rita. Have a good night. So I'll check your email tomorrow. I'll check into that. And then I'll write you back and let you know what's going on with it. Your dog just started howling in her sleep. That's funny. My dog got up and I forgot she was even in here. I was like, when she snored earlier or she like whistled or something, I was like, what? I was like, oh yeah. Which I just got a shampoo her because we don't have any carpet in this house. We finally got rid of all the carpets except for these little like throw rugs or whatever. These are the only 2 also. We don't have any other throw rugs in this house because I can't have throw rugs down because I might trip over them because of my vision. What was I going to say now? I don't even know what I was going to say. Oh, well, it doesn't even matter. Any news on Chelsea? No, I don't know what I was going to say, but that's really weird. Oh, but I did have something to show you guys before we get off of here. I was going to show you that thing about Matthew Perry. I did remember that. Okay. I forgot what I was going to say, but I remember that part. Let me show you guys this because I thought I shared this on my Twitter today. So if you're not following me over on Twitter, go follow me. Look, I got 179 followers over there. We're doing big things. I didn't have that many like the last time I checked. I had like under 100. So today when I checked, I was like, well, look at me. And I'm always verified. That way I can message people that are verified, like SF Investigates and the Chelsea Grimm case. I'll look that up too, see if there's anything on her before we get off the live. Let me actually pull that up because knowing me, I will forget. And been thinking about her all day. Okay, so also Caitlin Armstrong, she is supposed to be going to court tomorrow, like to start her trial. We don't know if it's going to be on TV or not TV. Let me see if it even says it here. Yeah, like I don't know what's going on. The person that I always usually go like get my like stuff from on Twitter, they don't even know. And I'm like, okay. So that's another case we're following. So we'll probably do that, cover that tomorrow, and get caught up. But this is the letter that Matthew Perry had wrote, or he put this one as like one of his social medias before. So I'm going to read this to you because I thought this was beautiful. It says, I've had a lot of ups and downs in my life. I'm still working through it personally, but the best thing about me is that if an alcoholic or drug addict comes up to me and says, will you help me? I will always say yes. I know how to do that. I will do that for you, even if I can't always do it for myself. So I do that whenever I can in groups or one-on-one. And I created the Perry House in Malibu, a sober living facility for men. I also wrote my play, The End of the Longing, which is a personal message to the world, an exaggerated form of me as a drunk. I had something important to say to people like me and to people who loved people like me. When I die, I know people will talk about friends, and I'm glad of that. Happy I've done something solid work as an actor, as well as given people multiple chances to make fun of my struggles on the World Wide Web. But when I die, as far as my so-called accomplishments go, it would be nice if friends were listed far behind the things I did to try to help other people. I know it won't happen, but it would be nice. So I thought that was very sweet. Matthew Langford Perry, August 19th, 1969, October 28th, 2023. Man. That's sad, isn't it? But I thought that was really sweet. Tomorrow will be 8 years since my mom passed. So, but it gets easier through the years. I hope Elisa's doing okay. I haven't seen her. If you're watching Elisa on replay, we're thinking of you. She just lost her mama, so that's so sad. Between people, like everyone losing someone, and then all this gun violence out there right now, it's just insanity. So I'm hoping it'll simmer down a little bit because we've had like 3 shootings now in one day. So I could see that. Massachusetts is known for its bars. But I'm going to jump off of here. That's all I had for you guys tonight. It was like a 2-hour live. We did 2 hours. Wow. Yeah, we did. It's 10:16. For some reason, I thought I came on later. That was last night, but I don't know. I thought it was a little bit later than it is, but that's cool. It's not that late. So pretty much the basis of the live was, Richard Allen's attorneys are wanting the judge off the bench. They don't want her. She doesn't want them to, be the defense attorneys for Richard Allen, in the courtroom because she's saying that they're just disseminating information everywhere and evidence. And they can't be having a trial by public. They need to be having it in the actual courtroom. So they went ahead and they hired in a new attorney for Richard Allen, which word on the street is the guy's not really good for Richard Allen. So we're going to have to see how this all plays out on Tuesday. So I will make sure I keep my eye out, my ear open, all that stuff, for all the good stuff. Jan, she's always up to date on this case too. So she always sends me stuff if I need it. And she always reminds me. So, but I'm Irish. Look at that. Yeah. Tampa. There was Tampa, Chicago, and one other place. Delaware. Crazy. But yeah. Okay. So nothing on Chelsea. Let me see. Wait, hold on. SF Investigates has something on here. 4 hours ago. Hold on. It says Chelsea Grimm inquired at an Arizona motel about using euros, aiming to stay off the grid. She also mentions changing her name. Oh, this is new. Okay, hold up a second, y'all. Hold on. Don't get out of here yet, y'all. We might have to do a live over this. He needs to tell me what he knows. I need to know what you know, SF. It says Chelsea Grimm inquired at an Arizona motel about using euros. We remembered that. We heard that part. Aiming to stay off the grid. We had heard that part. She also mentions changing her name during the conversation. We never knew that. That was, remember they redacted some? I've redacted the audio on her specific fears. These fears, along with untreated manic episodes, seem central to her disappearance. I now know she was in her car at 5:51 p.m. on September 30th, right where it was later found. Is that the picture she took? With sunset at 6:14 p.m., one has to wonder, did she try to hike out after blowing out both passenger side tires, becoming lost in the dark, or is she truly off the grid, starting anew? Those were my two things. I said either something happened to her when she tried to get out of there, because maybe I thought maybe because of, she took something, or I said the other thing was she wanted to go on her own, accord. But you can see she's turned now in this picture. So, and you can see her purse on her shoulder. There's no lizard. Where's the lizard? Because people were saying they thought they saw a lizard in the previous video on her shoulder, but there's no lizard. She's turned now. It says, as an investigator that works solely on missing person cases, I am often at odds with others when it comes to the sharing of case information. I stand by the importance of information, transparency, bearing criminal suspicions. Secrecy doesn't aid resolutions. Secrecy delays investigations and continues to put the missing persons in harm's way. I agree. While no crime appears to be at play here, Chelsea is vulnerable. Finding her is crucial for her well-being. Here's a second surveillance clip from 11 a.m., 12:28. This is 16 seconds long. Let me put it all the way back, and I'll play it a couple times for you guys. That way we can all kind of hear it. Now, I will tell you, she does say at one point, let me get to my messages on Twitter. I don't know why I didn't go through this way, but because I was talking to SF and he told me exactly what she said. That way we wouldn't be confused, because it's hard to kind of hear the audio. She says, that's why I don't actually feel this is a very good idea. And she's referring to using her credit card and her name because it could be tracked. So I might do a short video on this as well. If you see a short video come up for maybe 7 minutes or under, make sure you hit it and go hashtag Chelsea Grimm so we can push it out. Because I think she may not know she's wanted. Her parents have only done 2 interviews, one with News Nation, one with Law and Crime. They're wearing the same clothes and in the same position in the kitchen for both interviews. So it's not like her voice is being disseminated. Her name is being put out there. There's only a few channels, really covering her case. So we've been lucky to have SF Investigates there to give us these details. So let's listen to see what this is. This is crazy. Thank you, Cheryl, for asking how Chelsea was doing. And look how pretty she looks, but she does look a little sad right there.
Unless you take euros, or anyone in town exchanges euros. I was trying to stay off the grid. I don't really. That's the problem. I was hoping not to use the card. Unless you take euros, or anyone in town exchanges euros. I was trying to stay off.
Okay, so she's asking him, do you take any euros, any forms of exchange of euros? I don't know why she would say it like that. It was kind of weird how she said it the second time, but she said, I'm trying to stay off the grid. I mean, you'd have to really be upset with your parents to not say something. But then again, maybe she just doesn't know, because there's really only 2 interviews out there. See, this is the motel. Yeah, this is the motel. Okay, I'll keep playing it, and then I'll tell you what else they're saying. She doesn't really, and then he redacts that, and she said that's the problem.
Unless you take euros, or anyone in town exchanges euros.
Do you take euros or any forms of exchanges of euros? She seems pretty calm. She does not seem to be in a manic state to me.
I was trying to stay off the grid.
That's one thing I don't agree with. That I don't agree with the manic. Not right here. She's very aware of what she's doing. She's not like if she was manic right there, as soon as he shut her down and was like, no, she would have been like, no. Like, I need a room. I have to stay. Or, yeah, I feel like her parents know something's up. Yeah. She still looks together. Like I thought she looked good. And she does have the bag on her shoulder. I don't know if you saw my community post last night. As soon as I got off the live, I was over in another live. I was in Down the Rabbit Hole News, and I was watching hers on Chelsea. And as soon as she put her video up, I don't know if it was because, I don't know, maybe I saw it at a different light or something, but I could see the bag. And I was like, oh my gosh, she has a purse on. And it almost looks like the same color. But they said that they found her purse. So that's weird. Her purse was in the car. Unless she had 2 bags. She took an extra purse with her. She could leave one in the car and then take her wallet, stuff with her, and her other bag, and like a tote. But her dress is like really nice looking. It's white. It's still white. It's crazy. This is crazy to me. That's all I got for you guys. I'm really wondering where she's at. She might still be around there. Yeah. I wonder if the other PI is off the case yet. I should ask SF and see if he's, because I know that SF was done like on the 27th or something, like Friday. He was done with his part. That's terrible. But thank you guys all for being here tonight. If you see a short video from me, like I said, from about Chelsea Grimm, that's what it is. I'm just trying to get the word out there. So she was in Arizona. That's where she was last seen. So, but thank you guys for being here tonight. I will see you guys all tomorrow on the live. Have a good night, guys.